आप वेट कर रहे हैं कि जब इनकी दूसरे में बेल हो जाएगी तो इस वाले केस में अरेस्ट कर लेंगे उनको जेल में रखने के लिए। इट इज ओनली 7 years imprisonment. He is already in custody. अभी धमकाने का कोई क्वेश्चन भी नहीं है। So you don't want bail?
No minutes. We moved the
और
petition.
केस बन जाएंगे।
नहीं, हाँ, हमारा हमने पिटिशन में बोला आप हमको जब बाहर लेके जाते हैं एक 195 का मामला बनवा देते हैं।
आपकी पुलिस के सामने धमका देते हैं किसी को भी? बिल्कुल ही दम नहीं है क्या एमपी पुलिस में कि एक आदमी जो कस्टडी में है वो पुलिस के सामने विटनेस को धमका देगा?
Manoj, may just have the last order, man.
Yes.
The state was called upon to answer in this peculiar circumstance as to how can they oppose my anticipatory bail application and then refuse to arrest me as well.
Yes, state. Why you have not arrested him? He is in jail. आप वेट कर रहे हैं कि जब इनकी दूसरे में बेल हो जाएगी तो इस वाले केस में अरेस्ट कर लेंगे उनको जेल में रखने के लिए। वो जेल में है ना दूसरे केस में। योर इन्वेस्टिगेशन इज कंप्लीट। इस केस में क्या किया है आपने? क्या है इस मैटर में, क्या है इनके अगेंस्ट में?
कोई भी ऑफेंस 7 years से ज्यादा से पनिशेबल वैसे नहीं है। 195 का मैक्सिमम ऑफेंस है इनके ऊपर।
This is 438.
This is 438.
So a judgment was cited that 438 is not maintainable.
Luckily, I also got the time, my lords. Now the judgment which they cited, the Rajasthan High Court judgment.
Yes.
That was Sunil Kallani. Sunil Kallani was considered by the Bombay High Court and Sunil Kallani was considered by the Allahabad High Court after that, and they both say Sunil Kallani is not the correct proposition of law. They have distinguished Sunil Kallani and
yes,
I'm just citing.
So apprehension of arrest, court can always grant anticipatory bail.
My lords say
the production warrant after my lord raised this concern. So there were justified reasons as to why we had not done arrest for them.
Yes.
Now, in fact, the production warrant has been issued. Application has been moved, my lord, again because he's already in custody. So, as my lord have raised the concern, we have issued a production warrant.
No, my only concern is once he is enlarged on bail in another case, आप इसमें अरेस्ट कर लेंगे इनको, इसको आपने पेंडिंग रखा हुआ है।
हमने कहा कि इसको अरेस्ट कर दिया जाए because it is raising apprehension about the.
So you complete investigation. I am granting him bail, anticipatory bail. He is already in custody. कहाँ से धमकाएंगे?
हाँ, तो अब हमने इसको प्रोडक्शन वारंट जारी कर दिया है सर। इस प्रोडक्शन वारंट के लिए हमने लेटर लिख दिया है। मेरा ये कहना था कि
yes,
if they rely upon this production warrant, then my apprehension is further bona fide.
it is only 7 years imprisonment. He is already in custody. अभी धमकाने का कोई क्वेश्चन भी नहीं है।
नहीं, ये जब गए थे बाहर कस्टडी में, जब इनको हमने बाहर ले आना ही कंप्लीट तरीके से बंद कर दिया। दिस इज ओन केस। जब बाहर ले जाते हैं तब तक इसके खिलाफ एक नया एक प्रकरण दर्ज कर लिया जाता है। तो हम बाहर लेना बंद ही कर दिया।
So you don't want bail?
No minutes. We moved the
और
petition.
केस बन जाएंगे।
नहीं, हाँ, हमारा हमने पिटिशन में बोला आप हमको जब बाहर लेके जाते हैं एक 195 का मामला बनवा देते हैं।
Applicant has filed first application under section 438 of Code of Criminal Procedure for grant of anticipatory bail. Counsel appearing for applicant submitted that allegations were made that applicant had threatened one of the witness when he was being taken for conduct of MLC.
I was taken for MLC. वो वहाँ पे कैसे?
When applicant was being taken for conduct of कोई बात नहीं, MLC examination. Full stop. It is further submitted by counsel. It is further. No, though he is a history cheater, but you cannot keep him behind the bars. Freedom is important, fundamental right of a person.
So, but maintainability का हमने issue raise किया है।
वो मैं
That I'll deal with it. Only apprehension of arrest is required. That's all.
Particularly उस point पे दो judgment.
You have not arrested him. So you raised his apprehension that in this crime number also he will be arrested.
With me, Rajasthan High Court, Allahabad High Court, and Delhi.
I'll consider. Yeah, लिखा.
If further submitted that.
It is further submitted that offences alleged against applicant are bailable in nature. Are punishable up to 7 years of imprisonment. In these circumstances, applicant may not be arrested unnecessarily. Full stop. You are government advocate. Deputy Advocate General appearing for state opposed the application for grant of bail. It is submitted that applicant is already in custody. Therefore, anticipatory bail filed by applicant is not maintainable. Full stop. It is further submitted that applicant is a history cheater and have long list of criminal records. In these circumstances, applicant may not be released on anticipatory bail. Full stop. Any other objection?
So there is ample material on record to show that he has in fact threatened the victim in this case to give false evidence.
तो आपकी पुलिस क्या करती है? आपकी पुलिस के सामने धमका देते हैं किसी को भी? बिल्कुल ही दम नहीं है क्या एमपी पुलिस में कि एक आदमी जो कस्टडी में है वो पुलिस के सामने विटनेस को धमका देगा? क्या करते हैं आप?
वो अभी तक गैंग डिस्ट्रिक्ट कोर्ट में ऐसी घुस जाते
नहीं तो पुलिस ने कैसे धमकाने दिया? कुछ नहीं, सब फॉल्स है। क्या लिखा? He may not be granted anticipatory bail, heard the counsel for the parties. Government advocate appearing for state has relied on judgment of Bombay High Court.
ये मेरा है सर. This is mine.
Your-
Kalani is not the correct proposition of law.
Where is your?
I could have supplied the other day, my lord.
Has relied on the judgment of Rajasthan High Court
Sunil Kalani versus State of Rajasthan.
and
2020.
so and so, है ना? Please give me a copy later on.
I my copy it has been relied on by Delhi and Allahabad.
ये तो कोई दूसरा है.
हाँ ये इसको रिलाई किया था मैं उसको दे ही रहा हूँ.
It is submitted that said judgment has been relied upon Delhi High Court and also by Allahabad High Court. It is submitted that since applicant is in custody, therefore, application for anticipatory bail when applicant is in custody is not maintainable. Full stop.
ये आपने उस दिन इसका रिप्रोड्यूस किया गया कल्याणी को इस इलाहाबाद में मतलब क्योंकि मैं
Yes, I'll quote. I'll
इसमें
quote.
कोट किया गया इलाहाबाद में.
Counsel appearing for applicant opposed the aforesaid submission and submitted that Bombay High Court in case of Amar Mulchandani has held that anticipatory bail application is maintainable if applicant is in jail in some other crime number, and proposition laid by Rajasthan High Court in Sunil Kalani versus State of Rajasthan does not appear to be correct. Full stop. In these circumstances, he prays for grant of anticipatory bail, heard the counsel for the parties. Application under section 438 of Code of Criminal Procedure is filed when any person is having apprehension of his arrest in an offence. Full stop. A person is arrested for committing an offence in a particular crime number. In this case, in this crime number, applicant has not been arrested. Full stop. Since he has not been arrested, therefore applicant in this crime number can always file an application for anticipatory bail. He may have been under arrest in other crime number, but that will not curtail the rights of applicant for moving a bail application in this crime number under section 438 as he has not been arrested. In view of same, application filed by applicant for grant of anticipatory bail is allowed. Applicant be released on bail 50,000, 1 surety. नहीं 1 lakh कर दें. 1 lakh 1 surety. Conditions: applicant will not threaten the witnesses. Applicant will make himself available for investigation in the case whenever required. Any other condition?
बाकी पहले से conditions
Applicant, if released on bail in other crime numbers, then he will mark his presence before local police station each month. Applicant will not leave the country without permission of this court and surrender his passport before investigating officer.